In the state general election held on 13 December 2022, the National Alliance won 14 out of 15 seats. The Religious Party won 9 seats, while the Unity Party won 5 seats. The Reform Coalition through the Honest Party only won 1 seat. After the election, Haji Rafar from the Religious Party was appointed as the Menteri Besar on 15 December 2022. The Sultan later summoned the SLA, and its first meeting was held on 19 December 2022. On 23 December 2025, the Sultan received statutory declarations from 8 Assemblymen. These include 3 from the Religious Party and 5 from the Unity Party, all withdrawing support for Haji Rafar as the Menteri Besar. On the next day, 24 December 2025, the president of the Religious Party announced that the 3 RP assemblymen had lost their party membership immediately because they withdrew their support. On 25 December 2025, Haji Rafar went to the palace to ask the Sultan to dissolve the assembly. However, he was not allowed to enter because it was public holiday, which is a Christmas day. On the morning 26 December 2025, the palace announced that a new Menteri Besar had been appointed. Earlier that morning, the Sultan had sworn in Mr. Alvi with the support of 5 UP assemblymen, 1 HP assemblyman, and 3 former RP assemblymen. Haji Rafar argues that he is still the rightful Menteri Besar because he never resigned and was never dismissed. He also claims that Mr. Elvis doesn't have the majority support in the assembly, so the appointment is invalid. However, Mr. Elvis disagrees and says his appointment is valid because he has the majority support from the assembly members. He also argues that the appointment of the Menteri Besar is the Sultan's discretion and cannot be challenged in court.
So for the first issue, whether Haji Raha is still right for Menteri Besar, since he already lost the confidential of the majority of the assembly. So the rule that applicable in Federal Constitution is in the Article 43 Clause 2 Clause A that state that the cabinet shall be appointed as follows. That is to say, the Yang di-Pertua Agong shall first appoint as Perdana Menteri Prime Minister to preside over the cabinet a member of the House of Representatives who is his judgment is likely to command the confidence of the majority of the member of that house. Next rule is Article 43 of Clause 4. If the Prime Minister ceases to command the confidence of the majority of the member of the House of Representatives, then, unless at his request, the Yang di-Pertua Agong dissolve Parliament, the Prime Minister shall tender the resignation of the cabinet. So the case applicable in this, the first issue is in the case of Stephen Kaloni Kang and Tun Abang Haji Openg, it said that loss of confidence must be established through a formal vote of no confidence in the Legislative Assembly and not merely by the external elections. For the next case, Datuk Amir Kahar and Tun Muhammad Said Keruak state that loss of confidence may be inferred from surrounding political circumstances, including defections without a formal assembly vote. Third, in the case of Datuk Sri Muhammad Nizar Jamaluddin and Datuk Sri Dr. Zamri Abdul Kadir, it was stated that loss of confidence may be determined by the ruler using extraneous evidence such as statutory declaration, and a formal vote is not mandatory. So, to apply the Federal Constitution in the first issue is, in the Article 43 Clause 2 Clause A, the Sultan may appoint a new Menteri Besar if, in his judgment, the appointee is likely to command majority confidence which justify Mr. Elvis' appointment. For the Article 43 Clause 4, the application is when 8 out of 15 assemblymen withdraw their support, Haji Rafar clearly ceased to command the confidence of the majority of the assembly. Under Article 43 Clause 4, once confidence is lost, the Menteri Besar is constitutionally required to resign unless the ruler agrees to dissolve the assembly, meaning Haji Rafar could not continue in office merely by refusing to step down. So, to apply the case of Stephen Kaloni Kong in the Haji Kahar situation, in this case, the court held that loss of confidence must be proven through a formal vote of no confidence in the Legislative Assembly. Applying this strict approach, Haji Rafa could argue that since no such vote was held, his loss of confidence had not been formally established and he remained Menteri Besar. To apply Datuk Amekaha, the court recognized that loss of confidence can be determined from surrounding political circumstances, such as defection and withdrawal of support. Similarly, the coordinated withdrawal of support by 8 assemblymen in a Haj Rafa case objectively demonstrate that he no longer enjoyed majority confidence. To apply the case of Datuk Seri Muhammad Nizar Jamaluddin and Datuk Seri Dr. Azamri Abdul Kadir, the Federal Court confirmed that the ruler may rely on the extraneous evidence including statutory declaration to determine loss of confidence without requiring a formal assembly vote. Applying this binding authority, the Sultan was constitutionally justified, including that Haji Rafa had lost majority confidence based on the statutory declaration submitted. So, in conclusion, Haj Rafa ceased to be rightful Menteri Besar once he lost the confidence of the majority of the Assembly, as loss of the confidence may be determined through extraneous evidence under Nizar Zamri and Article 43, Clause 4 of the Federal Constitution. For the second issue is whether the appointment of Mr. Melvis as Menteri Besar is constitutionally valid on the basis that he commands the confidence of the majority of the member of the State Legislative Assembly. So, the first rule is Section 2, Clause 2, Clause A of the State Constitution provide that the ruler shall appoint as Menteri Besar a member of Legislative Assembly who, in the ruler's judgment, is likely to command the confidence of the majority of the member of the Assembly. Next, the rule that applicable is Datuk Seri Muhammad Nizar Jamaluddin and Datuk Seri Dr. Zamri Abdul Kadir, where the Federal Court held that the ruler may rely on extraneous evidence such as statutory declaration to determine whether an appointee is likely to command majority confidence and is not required to wait for a formal vote in the Legislative Assembly before making the appointment. So, applying Section 2, Clause 2, Clause A of the State Constitution, the Sultan was required to appoint a member of the Assembly who, in his judgment, was likely to command the confidence of the majority at the time of appointment. Mr. Elvis had the support of 9 out of 15 Assemblymen, which clearly constitute a majority. This provided objective and sufficient evidence for the Sultan to form the judgment that Mr. Elvis was likely to command majority confidence. To apply the case of Datuk Seri Muhammad Nizar Jamaluddin and Datuk Seri Dr. Zamri, where the court held that the ruler may rely on extraneous evidence such as statutory declaration and clear indication of support to assess majority confidence. Similarly, the Sultan in the present case act within his constitutional power by appointing Mr. Melvis and Mr. Elvis based on clear majority support without the need for a formal vote in the Assembly. Accordingly, the appointment of Mr. Elvis is constitutionally invalid. So, in conclusion, the appointment of Mr. Elvis as Menteri Besar is constitutionally valid. Under Section 2, Clause 2, Clause A of the State Constitution, the Sultan is entitled to appoint a member likely to command majority confidence. As Mr. Elvis had support from the majority of Assemblymen, the following the Federal Court reasoning in Muhammad Nizar Jamaluddin, the Sultan lawfully exercised his discretion, making the appointment valid.
So the third legal issue is whether the Sultan's discretion in appointing Mr. Elvis as the new Menteri Besar is constitutional. So, in particular, the question is whether the Sultan was legally entitled to appoint a new head of government based on his own assessment of majority support and whether such discretion is subject to judicial review. So, at the state level, this power is found in the 8th schedule of the Federal Constitution, particularly Section 2, Subsection 2, Paragraph A, which provides that the ruler shall appoint as Menteri Besar a member of the State Legislative Assembly who, in his judgment, is likely to command the confidence of the majority of the Assembly. So the phrase "in his judgment" is significant because it confers constitutional discretion upon the ruler in determining majority confidence. Further authority is found in Section 2, Subsection 4 of the 8th Schedule, which allows the ruler to disregard certain constitutional restrictions if it is necessary to comply with the requirement that the Menteri Besar must command majority confidence. So this judicial interpretation can be seen in two key cases. First, In Stephen Kalunikan and Tun Abang Haji Openg, the federal court held that where a state constitution expressly requires a vote of no confidence, that procedure must be followed. So therefore, a mere declaration of loss of confidence would be insufficient. However, this strict approach was later qualified by the federal court in Datuk Sri Muhammad Nazir and Datuk Sri Dr. Zamri's case, where the court held that where the Constitution does not expressly require a formal vote, loss of confidence may be established through extraneous evidence such as statutory declarations. So therefore, the Sultan's discretion, where when exercised on credible evidence, was held to be constitutional and justifiable only on limited grounds. So in applying this to the legal issue, relying on Nizar and Zamri, the Sultan was constitutionally entitled to treat these statutory declarations as valid, extraneous evidence of loss of confidence because the state confidence did not expressly require a formal vote of confidence through the state assembly before the appointment of a new Menteri Besar. So therefore, unlike Stephen Kalunikan's case, there is no constitutional provision which restricts the proof of loss of confidence solely to proceedings on the floor of the assembly. So therefore, the Sultan's discretion was exercised within constitutional limits and based on objective material. Accordingly, the Sultan was entitled to conclude that Haji Rafau no longer commanded majority confidence and that Mr. Elvis was likely to do so. And the fourth legal issue, so what happens when a casual vacancy has been officially notified by the Speaker and after the three assemblymen of the RP party cease to be members of their political party? So the issue here is concerns the legal consequences of casual vacancy once it has officially been notified by the Speaker. So, the ruling. Article 160 Clause 2 of the Federal Constitution defines a casual vacancy as a vacancy in a legislative seat occurring otherwise than by dissolution of the Parliament. And more importantly, in Section 7A, subsection 1, paragraph A, item 2 of the 8th schedule, provides that where a member is elected as a representative of a political party and ceases to be a member of that party, his seat shall become vacant immediately upon the Speaker's establishment of the vacancy. Therefore, once a vacancy is established, additionally, Section 9, subsection 5 of the same schedule requires the Election Commission to fill the vacancy within 60 days, subject to any constitutional exceptions. However, the scope of the Speaker's power was clarified in Jamaluddin bin Muhammad Razi and Sivakumar Varadaraja Naidu. In that case, the federal court held that while the Speaker may notify the Election Commission, the ultimate authority to establish a vacancy lies with the Election Commission, not the Speaker. So therefore, it established that the Speaker's role was procedural rather than determinative. So in applying this to the three RP assemblymen's case, they ceased to be members of the party following the party president's declaration. So this triggered Section 7A, subsection 1, paragraph 8, item 2, and that activated the anti-party hopping provision. And unlike the case of Jamaluddin, where the Speaker acted unilaterally and prematurely, the Speaker in this scenario merely notified the Election Commission of the vacancy. So therefore, once the Election Commission confirms the vacancies, the seats become vacant by operation of law, and the affected assemblymen cease to be members of the State Assembly. So from that point onwards, the Election Commission is constitutionally obliged to conduct by-elections within 60 days, unless an exception applies. So to conclude, once confirmed by the Election Commission, the three seats are legally vacant and the former assemblymen lose their legislative status as assemblymen, and the Election Commission must proceed to fill the vacancies in accordance with Section 9, subsection 5 of the 8th schedule.
For the fifth issue, under Section 2, Section 6 of the 8th schedule of the Federal Constitution, a Menteri Besar must have the confidence of the majority of the SLA. If the Menteri Besar loses this confidence, he has two choices. He can either resign with the Executive Council or ask the ruler to dissolve the Assembly. If the Assembly is dissolved, a general election will be held to choose a new government. However, If the ruler refuses the request to dissolve the assembly, the Menteri Besar is considered to have resigned and must leave his office. In the case of Muhammad Nizar, he asked the Sultan of Perak to dissolve the SLA. The Sultan refused the request and used his discretionary power granted under Section 18, Section 2, Paragraph B, Undang-Undang Tubuh Kerajaan Perak because he was satisfied that Nizar no longer has the majority support. This refusal was made using the Sultan's discretionary power under the Perak State Constitution. Nizar, however, refused to resign. He argued that no vote of no confidence had been passed in the assembly. The federal court later decided that the Sultan's actions were constitutional and valid, and Nizar was deemed to have been vacated his position as Menteri Besar. One scenario in this situation, Haji Rafar lost the confidence of the majority of the SLA. This happened when 8 assemblymen submitted statutory declarations withdrawing their support. Although Haji Rafar tried to request the dissolution of the assembly, the Sultan didn't approve his request. Instead, the Sultan proceeded to appoint Mr. Elvis as the new Menteri Besar. Based on the principle in the Muhammad Nizar's case, when the Sultan refuses to dissolve the assembly, the Menteri Besar, who has lost the majority support, must resign together with the Executive Council. If the Menteri Besar refuses to resign, his position is considered to be vacated by the law, even if there is no formal dismissal by the Sultan. In this case, the Sultan didn't dissolve the assembly and had already appointed Mr. Elvis as the new Menteri Besar. Therefore, Haji Rafar's argument that he is still the rightful Menteri Besar because he is not resigned or was not dismissed cannot be accepted. In conclusion, since Haji Rafar lost the confidence of the majority of the SLA and the Sultan refused to dissolve the assembly, his position as Menteri Besar is deemed to have been vacated by the law. Even though he refused to step down, the law treats his office as already vacant. As a result, no general election will be held because the assembly was not dissolved. Instead, the Sultan lawfully appointed Mr. Elvis as the new Menteri.